Hello. We are Group 16, comprised of Sean Fitzgerald, Maggie McGonigal, and myself, Thomas Walk. Today we will be talking to you about the company Infosys and the alleged visa fraud that they were caught up in. During this presentation, we will start off with a general overview of the case, as well as background information on the relevant visas and their policies, and the man Jack Palmer and the role he played throughout the case. We will then present a timeline of events that took place so that you may have a better understanding of how everything fits together. Next, we will give a more specific discussion on the court case, as well as how the False Claims Act impacted the motivation and outcome of the case. Finally, we will conclude the presentation by giving you our own perspective on the events that took place, and leave you with a couple of sticky points that require further reflection. Infosys is an Indian programming company that outsources technology consulting work. To accomplish this, they need to bring people into the United States from other countries, requiring the use of specific work visas. In 2011, they were investigated by the United States government for breaking multiple laws as far as these visa policies are concerned. More specifically, the issues surrounding Infosys involved two different types of work visas, the H-1B visa and the B-1 visa. Both of these are non-immigrant visas, but they differ in what work they allow a holder to perform during their stay within the United States. Furthermore, due to the large restrictions of the H-1B visa and the general difficulty that one must go through to obtain, they are quite expensive, costing thousands of dollars, and take a long time to actually be issued. On the other hand, B-1 visas are much cheaper, only a couple $100s, and can be obtained much quicker. It is for this reason that it is believed Infosys committed visa fraud, seeking to obtain B-1 visas when they were legally obligated to be using H-1B visas. To obtain a B-1 visa, there are three general requirements that must be met by the worker. First, the duration of the stay within the United States is very limited, reaching a maximum of only a few months. Secondly, the worker is required to only engage in performing business. Business counts as meetings, litigation, training, attending conferences, and similar things. Labor of any kind is strictly prohibited. Lastly, the worker is not allowed to obtain any salary from a United States entity during their stay within the country. Unlike the B-1 visa, the H-1B visa is granted to those workers who are seeking to enter the United States and start an employer-employee relationship with a company here. To do so, they must be seeking to enter a specialty occupation which relates to their specific field of study. It must also be proven that there are no other workers who qualify for the position already in the country who can be found immediately. In this position, the worker must be paid, at the very minimum, the prevailing wage for the occupation. Finally, there must be an H-1B visa number available at the time of issuance, as there are only a certain amount of visas that can be issued during any given year. Because of these varying restrictions, there are a lot of politics and criticism that go into the current United States visa policies. Immigration is a very controversial topic to begin with, and outsourcing does nothing to ease this, as many view it as taking jobs away from American citizens. The H-1B specifically comes under fire a lot, as it is also seen as promoting indentured servants and creating a global caste system. This is because it can be used as one of the steps to permanent immigration into the United States, and as such it forces the holders to behave in a certain way to earn their entrance into the country. Finally, and this is one of the prevailing issues surrounding the Infosys visa fraud case, drawing a distinction between what the holder of a B-1 visa may do and what the holder of an H-1B visa may do can be muddled and confusing at times, leaving a gray area where it is uncertain just what qualifies as business only and what qualifies as labor.
The key player in this situation was a man named Jack Palmer. Mr. Palmer was hired as a project manager by Infosys in 2010. After several months of working for the company, Mr. Palmer began to suspect that something was amiss and filed a report of visa fraud internally. Over the next several months, Palmer claims that he was sidelined from work and harassed in the workplace. This harassment and the accompanying threats led Palmer to struggle with depression, anxiety, and anger. Ultimately, Palmer filed a lawsuit against Infosys for his mistreatment. This lawsuit led to a federal investigation concerning potential visa fraud at Infosys. This timeline summarizes the major events in the Infosys visa fraud investigation and settlement. In March of 2010, at a meeting of executives in Bangalore, Palmer's suspicions of visa fraud were initially raised. In October 2010, an internal report was filed by Mr. Palmer regarding visa fraud. In February 2011, Palmer filed a lawsuit claiming punishment and sidelining. This lawsuit was eventually dismissed but spurred a federal investigation into visa fraud at Infosys. In June 2011, the founder and president of Infosys expressed concern about visa fraud publicly and resigned from the firm. In August 2011, Palmer's lawsuit was dismissed. However, in October of 2013, Infosys accepts a civil settlement with regard to the visa fraud investigation. The first major event in the Infosys visa fraud investigation was a lawsuit filed by Jack Palmer in an Alabama court in February of 2011. In this lawsuit, Palmer claimed that after filing an internal report at Infosys in October of 2010, he was sidelined from work, harassed, and repeatedly threatened. This suit was ultimately dismissed because Alabama does not recognize a public policy exception to at-will employment doctrine. Despite the fact that this suit was dismissed, it spurred a federal investigation into potential visa fraud at Infosys. The investigation into potential visa fraud at Infosys ultimately yielded several allegations. All of the allegations were related to foreign nationals working for Infosys in the United States. The allegations can be summarized as follows. 1. Infosys failed to maintain accurate I-9 records for many foreign nationals. 2. Infosys sent several falsified invitation letters to the U.S. Consular's office to secure B-1 visas for many of its employees. 3. Infosys provided B-1 visa holders instructions on how to deceive U.S. officials upon entering the country. These allegations were all outlined in the civil settlement document. In the same civil settlement document, Infosys issued an official response to the allegations. In this response, Infosys denied and disputed all of the allegations. Infosys claimed that the B-1 visas were appropriate for the work being done in the United States. Furthermore, they claimed that the invitation letters sent to allow their employees to obtain B-1 visas were accurate and appropriately detailed. Finally, Infosys stated that the instructions they issued to their employees regarding do's and don'ts of interacting with U.S. officials were in line with common industry practice. However, Infosys has since stopped using this memo. Infosys ultimately agreed to a $34 million civil settlement. In this settlement, they denied all of the allegations, however, agreed to pay the settlement to avoid trial. The settlement was divided among 3 federal offices, with $5 million going to Homeland Security investigations, $5 million to the Department of State, and $24 million to the United States Attorney's Office. This was the largest settlement of its kind at the time. An undisclosed amount of the settlement paid to the federal government was then awarded to Jack Palmer for his role in the investigation due to the provisions of the False Claims Act. This amount is estimated to be between $5 and $8 million. The False Claims Act is a piece of legislation that was passed by Congress on March 2nd of 1863 in response to rampant fraud that took place during the Civil War. Because it was passed during the Abraham Lincoln administration, it is commonly referred to as the Lincoln Law. This legislation is used to combat persons and companies who defraud governmental programs. The False Claims Act has a qui tam provision that allows citizens not related to the government called relators, to file a lawsuit on the government's behalf. Those filing a lawsuit stand to gain a portion, usually 15 to 25%, but in some cases up to 30%, of the damages should the lawsuit prove to be successful.
So, what do we think about whistleblowers? Should they be rewarded for their actions against the businesses for which they work? We believe that the rewards and incentives for whistleblowers are legitimate and good, but that there should be restrictions on how they gather their information. For instance, it should not be gathered in an illegal or immoral fashion. The False Claims Act incentivizes whistleblowers with a share of the settlement or monetary punishment of a company. However, many of the suits under the Act are settled, not tried. So the whistleblowers get their money even though the company was not proven guilty or innocent. The suits are rarely proven to be legitimate in court. To us, this seems unfairly bias the reward for the whistleblowers. If they are successful, then they can immediately become millionaires. If they are unsuccessful, life goes back to normal. And if the whistleblower is harassed or has any negative consequences in their workplace, the whistleblower can file a lawsuit a second time against the company because of discrimination. For a person like Jack Palmer, who knows his way around the court system, he can take advantage of this at the expense of even the most innocent company. There are a few cases where the False Claims Act has merited criticism. As discussed in our restrictions on the last slide, whistleblowers often engage in unethical activities in order to undercover illegal actions of a company against the government. This is generally regarded poorly by critics. Additionally, companies can be sued twice under both criminal provisions and the False Claims Act, even with the same offense. We find this to be questionably moral because the company has technically already been proven guilty and paid their recompense. Should they be punished again under exactly the same terms? We say no. This seems like a slippery slope, where the verdict is not governed by justice, but by savvy in the United States judicial system. When Infosys offered their contractors to American companies, that severely affected those American job markets because the company was offering similarly skilled workers with lower wages, the jobs that would have gone to Americans. For this reason, it is reasonable to expect that Americans were not hired or pushed off important teams because the company deemed it more efficient to hire contractors than internal labor. This is not unethical and can even be considered good business practice for some companies with limited resources. However, it only works if there is a limited number of cheap contractors. And Infosys was violating this by using B1 visas instead of the more difficult to acquire H1B visas. For Infosys, the majority of the $34 million in fines paid under the settlement of the False Claims Act was paid to the attorney's office, not back into the U.S. economy. This is unfair because individual Americans, as proven earlier, were the major victim of their actions. However, in this case, it is actually very difficult to pinpoint which Americans suffered by the scandal because of missed work opportunities. We've come up with a few alternative or more fitting punishments that could have been levied on Infosys. These include restricting their visa applications permanently, or for a period of time, not allowing them to or severely restricting their ability to conduct business in the United States, and potentially terminating employees who are instrumental in perpetuating the visa fraud. Some sticky points in scenarios like the one with Infosys are that the False Claims Act might actually lead to false accusations from whistleblowers looking to cash in on their share of the settlement. Finally, who are the actual victims of frauds like this one that duped the government? Where should the U.S.'s share of the settlement be paid? When a company rips off the economy, the cost to each American is basically incalculable. So here's our final verdict. There is gray area in the law where visas are concerned. This enabled Infosys to rationalize their actions in using the wrong visas. However, these actions were, at the very minimum, morally questionable, and they should have been examined and fixed within the company far before actually becoming implemented on a large scale. Their innocence or guilt was never proven in court, but from the evidence we've gathered, we consider them guilty of intentionally sidestepping the rules for avaricious purposes. Thank you for watching our presentation.